Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Gujarat ROC Adjudication Order in the matter of the Arnav Textiles Mills Private Limited dated 7th March 2022 for the violation of Section 203 subsection 1 of the Companies Act read with the Rule 8A of the Company Appointment and Remuneration of the Managerial Personnel Amendment Rule 2014 for the non-appointment of the full-time company secretary. Let's see the facts of the case. Company name Arnav Textiles Mills Private Limited, having registered office situated at Narol, Ahmedabad, Gujarat. Facts about the case. It is noticed from the record available from the MCA portal that paid up share capital of the company was increased to 6 crore 69 lakh with effect from 31st March 2016. However, the company had failed to appoint full-time company secretary during the period from 31st March 2016 to 7th September 2019 as per the requirement of Section 203 read with the Rule 8A. MCA appointed the ROC as adjudicating officer in exercise of the power conferred by Section 454 of the Act read with the adjudication rules. The ROC is entrusted with the power to adjudicate penalty as provided under Section 203 subsection 5 of the Act with effect from 2nd November 2018. As per the legal provision, as per the section 203 subsection 1 of the Companies Act applicable prior to 1st April 2020, every company belonging to such class or classes of companies as may be prescribed under Rule 80 of the Companies Appointment and Remuneration and of Managerial Personnel Amendment Rule 2014 shall appoint a whole-time company secretary. And as per the Rule 8A of Companies Appointment and Remuneration of the Managerial Personnel Rules 2014, a company other than the company covered under Rule 8, which has a paid-up capital of the 5 crore rupees or more, shall have a whole-time company secretary. And as per subsection 5 of Section 205, if any company makes any default in complying with the provision of this section, such company shall be liable to penalty of 5 lakh rupees, and every director and KMP who is in default shall be liable to a penalty of the 50,000 rupees, and where the default is continuing one, with a further penalty of the 1,000 rupees for each day after first during which such default continue but not exceeding 5 lakh rupees. In so-called notice, reply and personal hearing and adjudication notice has been issued to the company and its officer in default. The company letter dated 25th January 2022 has requested to grant 4 weeks time to submit necessary application in view of the prevailing condition due to pandemic of COVID. Majority office is working partially. Thereafter, a written notice was issued to the company and officer in default as per Rule 3 of Sub-Rule 3 of Adjudication Rules, and a hearing was fixed for 15th March 2022, that is today. But the company has requested by letter dated 23rd February 2022 to prepone the hearing in the matter due to company has to submit an compliance report to Honorable NCLT in the matter. Thereafter, as per the due process of the law and in the interest of justice, the adjudicating officer's submission of the company has been considered the ground and gravity of the pending matter before the Honorable NCLT, and so fixed the next date of the hearing on 4th March 2022 in pursuant of Rule 3, Sub-Rule 3 of the Company Adjudication Rules. On a scheduled date of the hearing, authorized representative represent the case. The company did appear and attend the hearing proceeding and submitted oral submission along with the reply that the present company is a closely held private limited company carrying on business activity in the textile field in the state of the Gujarat. As textile industry as a whole is passing through a very bad phase since the last couple of the years, and for survival of the textile sector, time and again government of India comes out of various policy and measures so that the sustainability and growth of the textile industry. Further, Learn Company Secretary submitted that majority of the section of the Companies Act along with the rules framed thereunder are providing exemption to private limited company, and therefore the company being private limited company by required to do minimum compliance of the provision of the act. Since company is a private limited company, a public at large is not involved and interested, and therefore public interest is not affected. The company had been regularly doing compliance with the provision of the Companies Act by taking expert advisory services of the practicing CS, and under able guidance and support of the professional of the company had been regularly doing all compliances and had never defaulted. CS never defaulted. Learn Company Secretary further submitted that in view of the applicability of the provision for appointment of full-time CS, the company tried to ascertain a suitable candidate for the post of the CS through the internal sources, but we were given to understand that against a number of the compliant companies which require CS, practically only 10% professional are available, and therefore there is a scarcity of qualified CS in the market. In view of the non-availability of qualified professional, even after diligent efforts of the company, no suitable candidate could be ascertained for appointment on full-time basis during the period of the default as indicated by your office. The amount mentioned in the notice of the adjudication proposed to be imposed on the company as well as the director of the company, who will be too harsh, and basic purpose of doing amalgamation of the company will be defeated if such harsh action are taken your office by your office. The presiding officer has submitted that during the procedural scrutiny of the scheme and other relevant documents served to this office under section 230 to 232 of the Companies Act, and office has observed that paid up share capital of the company was increased to 6.69 crore with effect from 31st March 2016. However, the company has not appointed full-time company secretary during that period as per the provision of section 203 read with the rule 8A. The company has appointed company secretary with effect from 8 April 2019. Hence, this is a fit case of imposing penalty against the company and its director officer, as ignorance of law is no excuse. Under the above circumstances, the undersigned has reasonable cause to believe that the company and the officer have violated the provision of section 203 subsection 1 and rule 8A. As the ignorance of law cannot be an excuse in view of the facts narrated above, the company and its officer, director officer in default are liable to put penalty as per section 203 subsection 5 of the Act. And in order, the presiding officer submitted that while adjudging quantum of penalty, having due regard to the amount of the disproportionate gain or unfair advantage whenever quantifier made as a result of default, or amount of loss caused to an investor or group or investor, or repetitive nature of default. Presiding officer submitted that with regard to the above factors of the we consider while determining quantum of penalty, it is noted that disproportionate gain or unfair advantage made by the noticee or loss caused to the investor as a result of the delay on the part of the notice to the redress the investor grievances are not available on the record. Presiding officer submitted that is observed that from the master data that the company paid up capital is 6.90 crore as per the last financial year. The turnover of the company is 12,26,526. Hence, it appears that the company does come under the ambit of the small company. Therefore, the provision of imposing lesser penalty as per the provision of the company shall apply to the company. Having considered the facts and circumstances of the case, and written considering written submission, oral submission by the authorized representative, the ROC impose a penalty as under on the company. There is the penalty of the 5 lakh rupees and penalty continue failure for 309 days, total 3,09,000. But maximum penalty imposed under this section for the section is for violation of subsection 5 of section 203, that is 5 lakh, and on the 2 director for the default, that is 50,000 on each officer in default, and for the number of the delay default for number of the delay continuing failure 309 days, that is total 3,59,000 on the 2 director for the period 2nd November 2018 to 7th September 2019. Notices shall pay the amount of penalty individually for the company and its director by way of the e-payment under the pay miscellaneous fee under the MCA category in MCA fee and payment of service within 90 days from the date of the order, and challan and SRN written after payment of penalty file in INC 28. If company prefer appeal against this order, then file appeal to regional director within the period of 60 days from the date of the receipt of the order, along with the certified copy of this order, and inform ADJ setting for the grounds of the appeal. Please note that as per the provision of section 454 subsection 8 subsection 1 of the Companies Act, where company does not pay the penalty imposed by the adjudicating officer or RD within a period of 90 days from the date of the receipt of copy order, company shall be liable with fine which shall not be less than 25,000 rupees but which may extend to 5 lakh rupees. Further, section 454 subsection 8 2 of the Companies Act, where an officer of default who is defaulted does not pay penalty within a period of 90 days from date of the receipt of copy order, such officer shall be punishable with imprisonment which may extend to 6 months or with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees or both. Thank you so much for watching this order.